Welcome, and thank you for participating in our webinar today. The title is How to Preserve Your Estate with a Living Trust. My name is Robert Firth, and I am the lead attorney in the law offices of Robert L. Firth. Now, before we get started, I want to tell you a little bit about myself and my credentials. I've been an estate planning lawyer for over 25 years. I did my undergraduate work at the University of Virginia, and I received my law degree from Washington University in St. Louis. I'm a member of the Real Estate and Trust section of the California Bar, which helps me stay abreast of the latest in estate and tax laws. My office is located on Adelina Road in Cathedral City, right off I-10 and Date Palm Road. I've helped thousands of families plan their estates over the years. Now, on a personal note, I chose to be an estate planning attorney because I'm a problem solver. I enjoy getting to know the client's family, identifying their estate planning goals, and then creating a comprehensive plan to accomplish those goals. It's very satisfying work. Now, in this webinar, you will find out how a living trust can protect your estate from probate, how proper planning can reduce or eliminate taxes, and how you can protect your children's inheritance, and a lot more. Let me give you an overview of our agenda. First, we're going to define what an estate is and what an estate plan is. Then we'll discuss some of the most common estate plans. We will also learn about the evils of probate and how a living trust avoids probate. We'll also talk about estate and income taxes, and then discuss some of the factors to consider in selecting the best attorney to help you with your estate planning. Now, we have a lot to cover, so that I ask you that when you have a question, simply hold that question until you and I have an opportunity to meet. We'll receive your questions and we'll be able to answer them during our free consultation that will be made available to you at the end of this seminar. Okay, let's get started by understanding what an estate is. Your estate is everything you own or have an interest in. That includes all of your personal belongings, the gross value of your house and other real estate, any cash in bank accounts or in retirement accounts such as IRAs, as well as any stocks, bonds, or brokerage accounts. Your estate also includes any insurance policies you have. And remember, it's the gross value of those assets at the date of death, not what you paid for them. So let me ask you, how many of you have taken time to add up the value of your estate? Well, if you're like most people, when you add up the value of estate, you'll be surprised to see that your estate is worth more than you think, especially when you add in your insurance policies and any death benefits your family will receive. All of those benefits are included in the value of your estate for the purpose of calculating whether your estate will go through probate and what estate taxes will be. So if you haven't added up the value of your estate, you'll want to do that. Now that we know what an estate is, what is an estate plan? Basically, it's a plan to give what you have, to whom you want, the way you want, and when you want. For example, if you want to give the proceeds of your estate to your son or daughter only after he or she reaches the age of 25, you can do that. It can also be a plan for how to avoid probate, which we'll define in a few minutes, as well as how to avoid any unnecessary taxes and legal fees. An estate plan is also a plan for how your estate will be managed in the event you become incapacitated, which means if you're legally unable to sign documents yourself, your estate will be managed by someone you choose in the manner you desire. With proper estate planning, the court will appoint someone to manage your estate in the manner it sees fit. So, as you can see, it's important to have an estate plan. And really, everyone needs a plan, and that's why you're at this seminar, because you recognize the importance of estate planning. Now, there are several common types of estate plans. No plan, a will, joint ownership, beneficiary designation, gifting, and a living trust. As I briefly explain each of these plans, see if you can identify the ones you have. First, you may have no plan. Some people call this the I love you plan. That's when, instead of having a written plan, it's simply your intention that your assets be distributed to the people you love upon your death, or that your family will take care of you in the event of your incapacity. Unfortunately, without a will or proper plan, your estate will likely end up in probate, and the court will distribute your assets according to the state's probate laws, It's called intestate succession, and you will have no control over who receives your assets. And if you become incapacitated, the probate court will determine who will manage your affairs, not you. The I love you plan, not really. It's more the good luck, I left you a mess to deal with plan. Now, you probably know what a will is, and you may have one. A will is a written document that names your beneficiaries and who gets what. It also names an executor, the person who will administer your estate when you die. You must meet certain legal requirements for such as date, testamentary intent, and 2 witnesses. I've had people come up to me when they find out I'm an estate planning lawyer and say, "Attorney Firth, I don't have to worry about probate because I have a will." Well, in point of fact, the only place a will has any validity at all is in probate court. And it only has the validity that a probate judge is willing to give it. So if you're using a will for your estate plan, you are guaranteed to go through probate. Joint ownership allows you to hold title and assets jointly with one or more people. For example, if you're married, you probably own your home and many other assets jointly with your wife. There are 2 types of joint ownership: joint tenancy with right of survivorship and tenancy in common. Joint tenancy is the most common. Upon the death of one tenant, the ownership automatically passes to the surviving tenant. By passing directly to the survivor, the asset does not become part of the estate and avoids probate. However, upon the last survivor's death, probate will occur. So joint tenancy doesn't avoid probate, it just postpones it. Also, joint tenancy can create income tax problems. For example, for married couples who own property in joint tenancy, there will only be a step up in basis for half the property. It's an easy fix, but most people fall into that trap. Tenancy in common allows you to share ownership, but without the right of survivorship. When a co-owner dies, the assets will not automatically pass to the survivor, but will pass according to the will of the deceased, or the court if there is no will. Assets under a tenancy in common will be subject to probate, because the assets will need to pass through the estate of the deceased tenant. Now, there are other potential problems with joint tenancy with right of survivorship. Let's take the Smith family for an example. Bob and Sue were married and they owned a beautiful home where they lived with their kids. Then unexpectedly, Sue passed away. And because the home was both owned under joint tenancy, the home automatically transitioned to Bob's ownership, and he and the kids continued to live in it. When the kids moved out and went off to college, Bob remarried a woman named Sylvia. Bob and Sylvia lived in the home for several years, and eventually, Sylvia's name was added to the title of the home as joint tenant. Then Bob died. And since Sylvia was a joint tenant, ownership of the home went directly to her. But what happened to the kids who lost both their parents? Did they inherit the family home? No. Even if Bob had a will, the home would not have gone to the kids. Because remember, wills do not control assets held in joint tenancy, and joint tenancy overrides the will. This type of situation is called an unintentional disinheritance, and it's not unusual, especially in our society when it's common for couples to remarry. Another way to transfer assets is through beneficiary designations. Whenever you set up financial accounts, such as types of bank accounts, IRA accounts, retirement plans, or insurance policies, the applications ask you to name beneficiaries who will receive the proceeds upon your death. Beneficiaries only need to present a death certificate to take possession of account, so these assets avoid probate. A drawback is that you need to keep your beneficiary designations current. True story. The son of a client of mine was clearing out his father's condo after he passed away and came across an old life insurance policy that named his father's first wife as the beneficiary. They had been divorced for over 20 years, but that didn't matter. The insurance company was contractually obligated to pay the $35,000 death benefit to the divorced wife. The irony? The first wife was suffering from dementia and living in a nursing home in Wyoming on state aid. The state of Wyoming got all the insurance proceeds. And that is why you need to keep your death beneficiaries current. Giving assets away while you're living is the easiest way to transfer assets. You can give up to $11,000 per year to as many people as you want without a gift tax consequence. Parents often give money and other assets to their children or grandchildren. However, there can be complications. First, any gifts to one individual that add up to more than $11,000 are taxable, as high as 40%. Also, by giving away assets, you're legally giving control of those assets to others. If your situation changes and you need your money or assets back, the person is under no legal obligation to give them back. When you give assets away, they're no longer legally yours, and you have little legal recourse if you change your mind at a later date. So it may be a good idea to use gifting, but I wouldn't use it to transfer your entire estate. The last common estate we're going to talk about is the living trust, which is what you've come here to learn about. First, let's understand what a living trust is. A living trust is called a living trust because it's created while you're alive, as opposed to a testamentary trust, which is created after death by language in your will. A living trust is a separate legal entity that goes on living even after you're gone. Once you create the trust, you transfer the title or ownership of your assets from your name to the name of the trust. For example, the title of your house could be changed from John and Mary Smith as community property with right of survivorship to John and Mary Smith as co-trustees of the Smith Family Living Trust. That way, the trust will own your assets, not you. So upon your death or incapacity, these assets will avoid probate because you don't own them, and the trust will go on operating based on your directions. Now, let's talk about probate for a moment. Probate is a legal process by which the court identifies, appraises, and transfers ownership of estate asset. The court also orders payments of any debts and taxes owed. There are 3 reasons to avoid probate: fees, delay, and publicity. We'll talk about each of these in detail. The first reason to avoid probate is because it's expensive. Probate fees vary by state, but they can total 3 to 8% of the gross value of an estate before deducting debts and mortgages. In California, where I practice, the lawyer gets 4% of the first $100,000, 3% of the next $100,000, 2% of everything between $200,000 and $1 million, and 1% of over $1 million. So if your estate is valued at $500,000, the basic legal fee for probate would be $13,000, and the executor of the estate gets a like amount. Then, of course, you have to add on filing fees, publication fees, and appraisal fees. For those who own property in several states, the estate can go through multiple probates, each one in a different state with additional fees associated with each state. The second reason to avoid probate is because probate delays the transfer of your estate to your family and heirs. It can take many months and sometimes even years to go through probate. Here in California, the current average time to go through probate is 18 months to 2 years. The third reason to avoid probate is because of the publicity. Most people keep their will in a safe deposit box or other secure location because it's a private document and they don't want people to see it. And yet, when your estate goes through probate, a notice typically must be placed in the newspaper to let the community know your estate is in probate, and your file is available at the county courthouse for anyone who wants to read it. This is an invitation for creditors or disgruntled heirs to make claims. It also opens your will to contest. For example, if a family member believes he or she should receive a more equitable portion of the estate, that person can file a lawsuit in probate court, and the court will decide the merit of the case. Because probate is public, anyone can find out the size of your estate, who it's going to, and the names and addresses of your beneficiaries, and the day that they will receive those assets. As you can imagine, scammers can easily take advantage of this knowledge. So to sum it up, probate is expensive, lengthy, and a public process. It's not a pleasant experience, and your family could miss out on a significant portion of your estate. Well, the next step is to schedule a free consultation. All we ask is that you schedule your appointment within the next 2 weeks while the information you've heard is fresh in your mind. And if you're a married couple, both spouses must attend that free consultation. Now here's what's going to happen during your free consultation. We're going to ask a lot of questions about you, your family, and your assets. We will identify all of your estate planning goals, and we'll give you a comparison of what would happen if you went through probate or if you had a living trust. Then you can determine the best type of estate plan for you. There's no obligation to move forward. This consultation is merely a way for you to get all your personal questions answered and so that you will know how you'd like to proceed. Consultations are available online or in person, although I find that people get more out of the consultation when they meet me in person. Now, when you make your appointment at the end of this seminar, you'll receive a discount worth $200 off your estate plan. Again, all we ask is that you schedule an appointment within 2 weeks and both spouses must attend the appointment. So, if you would like a free estate planning consultation so that you can get your personal questions answered and find out what type of estate plan would work best for you, then you can either call my office at 760-770-4066, or you can click the Contact Me box on my website. All you have to do is click and type in that you've attended my seminar and you'd like to schedule a free consultation with me. Someone in my office will get right back to you and get you on my calendar within the next 2 weeks. So how does a living trust avoid probate? Because it's recognized as a separate legal entity, separate and apart from you. When you fund or transfer your property to the name of your trust, the living trust owns the property, not you. So you may die, but the trust lives on, with the instructions as to how the property will be distributed. Therefore, your assets will bypass probate. But the trust has to be funded to avoid probate. This is a critical and all too often overlooked. Funding is crucial. A living trust will be ineffective unless it's funded. This means your assets must be transferred to the name of the trust. This is known as funding the trust. Each year, thousands of Americans take the time to set up trusts but fail to fund them. Funding the trust sounds complicated, but it's not. Your attorney will help prepare new deeds transferring your real estate into your trust. I always do that for my clients. And a document called a certification of trust, which you use to notify your banks and other financial institutions directing them to change the name on your accounts. That's how you eliminate probate. If the assets aren't retitled and you become incapacitated, your durable power of attorney can get the assets into your trust. But the power of attorney terminates at your death by operation of law. So upon your death, if assets are still in your name and not in the name of your trust, those assets may still have to go through probate. Let's start by talking about the mechanics of a living trust. First, the trustor, also called grantor, settlor, trust maker, all means the same thing, sets up the trust with the advice of an attorney. Only the trustors can make changes to the trust. The trustee, or co-trustees, manage the trust assets. Trustors typically serve as initial trustees, but you can also choose to have a professional trustee such as a bank or attorney. Trustees have complete control of the management of the assets. As trustee, you could buy, sell, or do just about anything you want with assets in the trust. And if the trustee becomes incapacitated or passes away, the co-trustee still has complete control. Now, upon the incapacitation or death of the initial trustees, the successor trustees should take over management of the assets, following the trust's specific instructions for paying the debts and distributing benefits to the beneficiaries. In most situations, a successor trustee is an adult child, trusted friend, or a professional. Trustees will also be named in the trust. They get to use and enjoy the property in the trust. While you're alive, you're the beneficiary, and upon your death, the persons you name in the trust will receive the benefits of the trust. A revocable living trust can be changed at any time by the trustor. So, as you age and your family circumstances change, you can change your trust to reflect those changes. You can change trustees, beneficiaries, or any instructions you desire. Now, with the proper estate plan, you can also protect your estate from estate taxes. There are two kinds of estate taxes: federal estate taxes and state taxes. Now, with the new tax laws, most Americans don't have to pay federal estate taxes because the tax only applies to assets exceeding $11.2 million. And good news, California has no estate or inheritance tax. It's one of the few things California doesn't tax. If you haven't valued your estate, you could be surprised at how much it adds up to. New tax law changes over the last years have caused income taxes to rise above state taxes. In 2018, the federal estate tax rate is 40%, while the federal income tax is approximately 39.35%, which combines the maximum federal income tax rate and a maximum Medicare tax. California's income tax maxes out at 12.3%, so we have to take that into account too. If you're single or in a relationship but not married, you have special planning issues because you have no legal partner who will be recognized by the courts in the event of your incapacity or death. Have you thought who will manage your assets and make health care decisions for you if you become incapacitated? Or who will be the beneficiaries of your estate? If you don't name the person to manage your estate or be your beneficiary, the probate court will, because most states don't recognize or protect non-relatives or domestic partners. If you want to name a significant other or a beneficiary or manager of your estate in the event you become incapacitated or pass away, you have to have a written estate plan. I want to share a story with you about my clients Jack and Harry. Jack and Harry had been together as a gay couple for over 20 years, but they had never married. Jack was from Oklahoma, and his family back home was opposed to gay marriage and gay relationships. Harry was afraid that if something happened to Jack, Jack's family would take him back to Oklahoma, and not only would Harry never get to see Jack again, he wouldn't be able to enjoy the benefits of the life they had created together. To allay their concerns, I created a joint trust which gave both Jack and Harry control over their assets. I created advanced health care directives, which gave each the power to make medical decisions for the other. And I created a document which gave Harry an absolute right to visit Jack if he was in the hospital or nursing home with no interference from the relatives back in Oklahoma. Their fears were allayed. Here's another one. Tom and Mary came in to see me. They were on their second marriage and each had children from previous marriages. Tom and Mary wanted to be certain that when the first one died, the surviving spouse could not amend their living trust and disinherit the children of the deceased spouse. So I created a trust that split into a survivor's trust and a decedent's trust when the first spouse died. For example, if Tom died first, Mary could do whatever she wanted with the survivor's trust and could use the assets in the decedent's trust if she needed them, but could not change the death beneficiaries of the decedent's trust. And that would guarantee that the children from both spouses would inherit something. I've done similar things with life estates and personal residence for the surviving spouse too. Now, to sum up the benefits of a living trust, you would want to consider setting up a trust if you own a home or property, you want to pass your estate to your heirs with as little delay or expense as possible, you want your affairs to be managed the way you direct if incapacitated, you want your affairs to remain private, and if you own real estate in more than one state. There are some additional benefits of estate planning. We can eliminate or minimize estate taxes. We can minimize income taxes. We can provide discretionary distributions to children for education. We can accomplish other benefits that are unique to your situation. Business concerns, special needs planning for a disabled child, etc. I've yet to have a problem I couldn't solve with a properly drafted estate plan. So how do you determine the best attorney to assist you with your estate plan? Here are some factors to consider. Obviously, you want an attorney with significant experience in estate planning, because you know most attorneys are generalists, meaning they do a little bit of everything. And if you're asked, do you do estate planning, they're likely to say yes. However, my recommendation is to select an attorney who focuses on estate planning and has a lot of experience, because this field is highly complicated. Ask them how many living trusts they've done. It should be well over 100. You also want to select an attorney who has the right credentials, the right training, someone who stays up to date on taxes and changes in the law. Also, you want to select an attorney who has positive client reviews. Successful attorneys will receive reviews from their satisfied clients, and those reviews are posted on their website or available online through viewing at google.com or avo.com. Now, To give you some information about how I fit in here, as I said before, I have over 25 years experience in estate planning and have drafted literally thousands of trusts. I'm a graduate of Northwestern University's National Trust School and have been a member of the National Network of Estate Planning Attorneys. I'm a member of the California Bar's Trust and Real Estate section. I keep up to date on the latest law relating to estate planning by regularly attending legal courses. I'm proud to say Palm Springs Life magazine has identified me as a top lawyer in the estate planning field for 6 years in a row. If you go to avo.com, a website for lawyers to interact with prospective clients, you will find that I have an outstanding rating and have been given the Client's Choice Award. If you Google my website, firth.law, you'll find a number of client testimonials. Now, I'm going to give you the fees for setting up a living trust at my firm and what the fees include. So get out your pens because I want you to take notes of them because this is important to remember. At our office, the standard fee for a living trust for a single individual is $2,400. For married couples, the fee is $2,800. Now, that standard fee will work for most of you. Of course, if there's a special situation that calls for more advanced estate planning, just as for clients with a special needs situation or significant real estate holdings, the fee could be more. But for most of you, the standard fee should work. We try to make setting up your estate plan affordable by offering different payment options. For example, we accept payment by credit card. You might even get during your airline miles too. I ask for half of the fee when we sign the retainer agreement and the balance when I deliver the documents. Now, our fees are pretty middle of the market. There are attorneys who charge more and there are attorneys who charge less. And you might be asking yourself, well, why wouldn't I want to go to an attorney who charges less? Because it's always nice to save money, right? But you also want to think about quality and service. After all, when are you going to know if your estate plan was properly prepared or not? Yes, it can be a little too late then, isn't it? What I'm trying to do is give you a little free advice. Avoid bargains when purchasing parachutes, scuba gear, and estate planning. Now, I'll explain what our fee includes. It includes the living trust as well as all the ancillary documents that go with the trust to help make it work. Let me quickly review what some of those important ancillary documents are. There is a pour-over will, which is the backup in case you didn't get any of the property in your trust while you were alive. There is a comprehensive durable power of attorney, which helps fund the trust if you're incapacitated and takes care of other loose ends not covered by the trust. There is an advanced healthcare directive with a living will and a HIPAA release, which allows your agents to make medical decisions for you if you're unable to do it yourself. We also have a section there that includes funeral and memorial directions. We prepare a deed for your primary residence, and we do funding assistance as necessary to help our clients. Now, let's take a moment to review what we've covered so far. First, you know what an estate is and what an estate plan is. We've also covered income and estate taxes and what you should consider when selecting the best attorney to help you. What the fees are for setting up a trust. There's only one final thing you need to know, and that's what's the next step. Well, the next step is to schedule a free consultation. All we ask is that you schedule your appointment within the next 2 weeks while the information you've heard is fresh in your mind. And if you're a married couple, both spouses must attend that free consultation. Now, here's what's going to happen during your free consultation. We're going to ask a lot of questions about you, your family, and your assets. We will identify all of your estate planning goals, and we'll give you a comparison of what would happen if you went through probate or if you had a living trust. Then you can determine the best type of estate plan for you. There's no obligation to move forward. This consultation is merely a way for you to get all your personal questions answered and so that you will know how you'd like to proceed. Consultations are available online or in person, although I find that people get more out of the consultation when they meet me in person. Now, when you make your appointment at the end of this seminar, you'll receive a discount worth $200 off your estate plan. Again, all we ask is that you schedule an appointment within 2 weeks and both spouses must attend the appointment. So, if you would like a free estate planning consultation so that you can get your personal questions answered and find out what type of estate plan would work best for you, Then you can either call my office at 760-770-4066, or you can click the Contact Me box on my website. All you have to do is click and type in that you've attended my seminar and you'd like to schedule a free consultation with me. Someone in my office will get right back to you and get you on my calendar within the next 2 weeks. I want to thank you for attending our webinar today. I hope you got a lot out of it, and I'm looking forward to meeting with you soon. Go ahead and click the button now to request a free consultation. Talk to you soon.